An attorney has a duty of loyalty to their client, but what if the duty to one client conflicts with the duty to another? Conflicts of interest are covered in ABA Model Rules 1.7, 1.8, 1.9, 1.10, 1.11, and 1.13. Each rule discusses a different conflict and also whether the conflict can be waived by the clients. The first type of conflict occurs when the attorney represents both the plaintiff and the defendant in the same case. The attorney cannot represent both clients with different goals while maintaining confidentiality. Some jurisdictions, however, allow the same attorney to represent both the husband and wife in a divorce. Another conflict occurs when the attorney represents the plaintiff and defendant in different cases, even though the cases may be related. Say that an attorney represents Tom in a suit against Dave. Once the case has ended, Dave asks the attorney to represent him to file for enforcement of the original judgment. The attorney cannot represent Dave against Tom as the matters are too closely related. An attorney may not sue a current client in a different lawsuit. If the attorney represents an insurance company, he or she may not sue the insurance company through another client. Again, issues of confidentiality and loyalty arise during this type of representation. Two clients generally cannot be represented by the same attorney, even if their interests are the same at the beginning of the representation. For criminal cases, this could mean that two people charged with robbery have the same attorney. This is allowed in certain circumstances if both clients waive any conflict that may arise in writing. In civil suits, clients must also be advised of the possible conflicts. If the interests of each client become vastly different, then it may be necessary to waive the conflict in writing or obtain alternate counsel for one or both of the clients. Finally, there may be a situation where two clients seek joint representation for a matter that is not going to be litigated, such as for the execution of a will or prenuptial agreement. Although it may seem that the parties agreed to the terms on the surface, wills and prenuptial agreements are examples of documents that may be contested in the future. Another conflict can arise if the attorney's personal interests are not aligned with the client's. An attorney cannot take a case if the representation could be materially limited by the attorney's own interests. If, for example, an attorney was a shareholder in a corporation, then it would be inappropriate for that attorney to agree to represent someone in a suit against the corporation. The final type of conflict exists between present clients and those currently represented. Even after the representation ends, an attorney has a duty of loyalty to his or her client. If the attorney determines that the new case is substantially related to the prior case, then he or she can request the former client's consent to represent the new client. There are other situations that are either prohibited or strictly limited. Attorneys, as well as paralegals, cannot accept any substantial gifts from a client, including jewelry, vacations, or a bequest in the client's will. Attorneys also cannot provide gifts or financial assistance to clients unless it is in terms of reduced legal fees. It may seem advantageous to have a client sign an agreement for the media rights regarding his case so that the attorney can write a book about the situation. However, this cannot be done until the case is over. Similarly, attorneys cannot represent someone in order to take a percentage of the recovery unless there is a written contingency fee arrangement, the case is civil but not a divorce case, and the arrangement is reasonable. If a client does not pay the attorney can place a lien against the client. Other than these two circumstances, an attorney can take no ownership interest in the case. An attorney also cannot enter into a business agreement with a client unless the agreement is in writing, signed by the client, and contains fair terms for the client. What if the client has someone else paying their legal fees? In that type of case, the attorney must not be influenced by the third party, must preserve confidentiality, and the client must consent to having their legal fees paid by the third party. Attorneys and paralegals are also prohibited from having sexual relations with clients unless the relationship started before the legal representation began. There are also restrictions regarding opposing attorneys. If the attorneys are related or if they are married, then each client must consent to continued representation. If the attorney represents clients in either a joint representation or class action suit, he or she must discuss any proposed settlement with each and every client, just as if the suits were separate. The final limitation of representation concerns an attorney limiting his or her liability with the client. A client must have independent representation in order to limit their attorney's liability. Likewise, if an attorney wants to settle a liability claim with a current or former client, they must advise the client in writing to seek independent representation regarding any settlement. How are the rules different if the client is an organization or corporation? The organization itself is the client, not the people associated with the organization. Although the attorney will interact with owners, shareholders, and officers of the corporation, the duty of loyalty lies with the corporation itself. If authorized representatives of the company are engaging in illegal activities, it is the attorney's responsibility to report to the highest executive of the organization. Other than this report, attorneys and paralegals are bound by confidentiality and may not report wrongdoing outside the corporation. For the most part, an attorney that identifies a conflict of interest is prohibited from continued representation. This conflict is imputed to the rest of the law firm, meaning that no attorney at the firm can represent that client. If the conflict is of a personal nature and there is no risk that the representation will be limited, the attorney may be screened from the case, but the firm may continue representation. Clients are also able to waive any conflicts, but any waiver must be done in writing. Paralegal conflicts are not strictly prohibited as they do not directly represent clients. However, those situations can cause conflicts for the firm. Screening occurs when the attorney who has the conflict is isolated from any information regarding the case. This can be tricky, and if there are any concerns about a conflict of interest, the firm and attorney must prove that the screen was in place and was actually used correctly. Some firms choose to refuse or withdraw from representation rather than risk a potential conflict from a faulty screening process.